Today's topic is sources of tax authority, and I'm really pleased to have a guest speaker with us today.
I'm Ashley Ahlbrand, and I'm the Assistant Director for Public Services at the Jerome Hall Law Library at Indiana University Maurer School of Law.
And I'm Leandra Letterman, and it's time to break into tax.
Tax is unmistakably a complex area of law. Not only is the subject vast and intricate, but it changes quickly and regularly compared to other areas of law, and thus it's vital for practitioners to keep abreast of all recent and forthcoming developments. Because of the complexity of the subject, the IRS issues a number of different types of documents throughout the year that address and explain these changes, and non-governmental, like commercial explanation and analysis, abounds as well. Now, from a research standpoint, there are both pros and cons to this abundance of resources. The pro, of course, is the sheer volume of materials and research tools specifically designed to elucidate tax law and facilitate the work of tax practitioners. The con, though, really is kind of the same thing. The sheer volume of materials means that knowing what to look to as authority when researching tax law can be confusing and overwhelming.
Let's turn to the topic of what is authority in legal research.
So to make things even more complicated, when we talk about authority in legal research, the term arises in different contexts. The terms you're most likely to come across are primary and secondary authority, or precedential and persuasive authority. In income tax research, you may come across an additional term, substantial authority. Let's talk about what each of those means.
Let's start with primary versus secondary authority.
Primary and secondary authority really refer to the nature of the sources. Primary authority in legal research is the law itself, such as a statute or a case. An easy way to think about primary authority is to think about the three branches of government, because all three produce documents that have the force of law. Congress, the legislative branch, enacts statutes. Judges, in the judicial branch, create law through their case opinions, and in the executive branch, which includes the president or at the state level, the governor, as well as administrative agencies, we get executive orders and proclamations, as well as administrative regulations. Now, on the other side, we have secondary authority, which is a broad category of materials that explain, analyze, or otherwise critique the law. Most often, we think of secondary authority as non-governmental publications, like legal treatises or law journal articles, most often written by tax scholars and practitioners. But this category also includes some publications from governmental bodies whose intent is likewise to explain or analyze the law.
Let's now turn to the difference between precedential and persuasive authority. Ashley, can you walk us through that?
Sure. If a source is precedent, which we also sometimes refer to as binding or mandatory authority, then it's a source I must rely on in my research. Persuasive authority, on the other hand, is non-binding, but it may be helpful as support in my legal argument. When we think of persuasive authority, I think we most commonly think of secondary authority, again, like legal treatises or law journal articles. But somewhat confusingly, primary authority outside of my jurisdiction can likewise be persuasive authority for me. For example, if I were researching an issue of Indiana state income tax law, cases from the Indiana Supreme Court would be precedential authority. But a case from Ohio or New York that was relevant to my legal issue could only be used persuasively because those states are outside of my jurisdiction and would therefore not be binding on my research question.
So within primary and secondary authority, how does hierarchy of authorities work?
That's a great question and kind of a complicated issue. So let's run through an example. If in my research I come across a statute within the Internal Revenue Code and a US Supreme Court case that both address the question I'm researching, which one would have the highest authority? Both of them are primary authority, but if the statute is good current law, then the statute ultimately has the highest authority.
Ashley, you mentioned earlier a concept that's specific to federal income tax law, which is substantial authority. Can you go over what that is?
Sure. In income tax law, one provision of the Internal Revenue Code notes that if the taxpayer understates their income tax liability, there's a possibility to have the substantial understatement penalty waived if the taxpayer can show substantial authority for their position. A corresponding Treasury regulation explains this further and goes on to list the types of documents the taxpayer can show to establish this substantial authority.
Let's turn to the issue of which types of authority are included within substantial authority under the Treasury regulation.
The regulation lists several different types of documents as potential sources of substantial authority, from tax statutes and cases to a variety of IRS guidance documents. And because that sheer volume of tax research resources can be overwhelming, I thought the sources listed in this Treasury regulation would serve as a good framework for discussing the major sources of authority in tax research. Other than the US Constitution, the highest authority in federal tax law is statutes. The Internal Revenue Code comprises Title 26 of the United States Code. This is where the vast majority of federal tax statutes can be found, though it is worth noting that other tax provisions can also be found outside of Title 26. The Patient Protection and Affordable Care Act, for instance, contains tax-related provisions that are codified in Title 42 of the US Code, which pertains to public health and welfare. If your tax research involves foreign or international law, there may be tax treaties between the United States and another nation that would likewise have topmost authority in your research.
Another really important source of tax law is regulations. Ashley, can you walk us through what administrative regulations are?
The Treasury Department and other administrative agencies have the authority to promulgate rules or administrative regulations that enforce tax law. When researching tax regulations, you may come across them in three different stages. The typical rulemaking process begins with an initial publication of a proposed regulation in the Federal Register, also referred to as a Notice of Proposed Rulemaking, or NPRM. The IRS may also publish an advance notice of proposed rulemaking to get input even before a proposed regulation is drafted. In the typical process, the publication of a proposed regulation triggers a notice and comment period when the public can weigh in with feedback to the agency about the proposed regulation, which the agency then considers before publishing a final regulation. Final regulations in tax are referred to as Treasury decisions, or TDs, and are published first in the Federal Register and then codified in Title 26 of the Code of Federal Regulations. Now, while this is the typical rulemaking process, it's time-consuming, so occasionally you'll come across temporary regulations as well. Temporary regulations are effective immediately. They're often issued after new Internal Revenue Code sections become law to guide taxpayers more quickly before the IRS goes through the comment and revision process. Under current law, a temporary Treasury regulation can remain in effect for up to 3 years, and it must be issued simultaneously as a proposed regulation.
Let's now talk about revenue rulings and revenue procedures.
A revenue ruling is official published guidance issued by the IRS interpreting the Internal Revenue Code, related statutes, and regulations. A revenue ruling applies the law to a factual situation to provide guidance to taxpayers experiencing a similar situation. Revenue procedures outline the procedures for complying with tax law, such as claiming benefits or making elections. While a revenue ruling generally states an IRS position, a revenue procedure usually provides return filing or other instructions concerning an IRS position.
Let's now turn to case law.
Because tax law is statute-driven, researchers look to case law to see how judges have analyzed, interpreted, and applied tax statutes to particular fact patterns. Like other areas of case law, tax cases can be precedential or simply persuasive. In cases that address new or unusual points of law, the opinion is more likely to be published or reported by the court, and therefore serve as precedent for future litigation. One other point of note when discussing case law in tax is the IRS's position when a court rules against the agency. At its own discretion, the IRS will often issue a memorandum known as an action on decision. An action on decision explains the IRS's decision not to appeal the adverse decision and whether the agency is acquiescing in their position based on that decision. When the IRS decides to continue litigating the matter in future cases, it often issues a notice of non-acquiescence, stating why the agency has decided to continue litigating the issue. If the IRS instead decides to stop litigating the issue, it typically issues a notice of acquiescence.
Let's now turn to legislative history and indicators of congressional intent.
An additional source of substantial authority in tax law is the explanation given by the drafters of tax legislation, Congress. You might seek out legislative history on a tax provision to discern legislative intent. The primary sources for legislative history are committee reports, and it's also advisable to look at floor statements when the legislation was discussed and voted on the floor of the House or the Senate. Additionally, the Joint Committee on Taxation offers general explanations of federal tax legislation known as the Blue Book. The Blue Book is another source that can be consulted to establish substantial authority in income tax law.
Next up, we have private letter rulings and technical advice memoranda.
Private letter rulings are statements from the IRS to an individual taxpayer, offering the IRS's interpretation of tax law in that specific situation. A private letter ruling is non-precedential. It can be relied on by the individual taxpayer for that particular instance, but cannot be relied on in future transactions.
One thing to note about private letter rulings is that they usually are not free. So the IRS, for example, charges a fee to get a letter ruling.
If the IRS feels that the situation expressed in the private letter ruling may be applicable to other taxpayers, the agency may use the facts from that private letter ruling as the basis for a revenue ruling. Similar to letter rulings are technical advice memoranda, or TAMs. These are written advice from the national IRS office to regional offices and pertain to completed tax transactions rather than proposed transactions.
Let's now turn to IRS General Counsel memoranda, notices, and announcements.
Rounding out the list of substantial authority, we have IRS General Counsel memoranda, notices, and announcements. That first category, General Counsel memoranda, I almost didn't include in today's video because the IRS no longer issues these and hasn't since the 1990s. However, the Treasury regulation on substantial authority still lists General Counsel memoranda, and they may still be discoverable when researching. So if you come across them, a General Counsel memorandum provides the reasoning and authority used by the agency in revenue rulings, private letter rulings, and technical advice memoranda. Notices from the IRS are essentially a way for the agency to provide guidance on a topic that will soon be covered in a revenue ruling, procedure, or regulation. Notices are faster to publish than those other more authoritative documents, so this is a quicker way for the agency to produce guidance. Announcements run the gamut, covering all nature of matters. But two common types of announcements from the IRS that a taxpayer might rely on to establish substantial authority are corrections to previously issued revenue rulings, revenue procedures, or regulations, and extensions of time for filing. So here on screen again are those sources of substantial authority. Some are more authoritative than others, and authority can be weakened in certain circumstances as well. Lengthy as this list of documents is, it's still not a complete list of all the different documents the IRS produces, such as the variety of operational publications like the Internal Revenue Manual that provide guidance to IRS employees on the policies and procedures of the agency. Not to mention all the rich scholarly explanations and analyses of tax law available to students and practitioners today. Knowing what documents to look for is only half the battle. Because tax law changes so rapidly, it's also incumbent on students and practitioners of tax law to stay up to date on the latest. Fortunately, there are several publications and resources that can help with this.
There are a lot of choices for daily tax news and places to keep up with tax law. Can you overview those for us, Ashley?
Sure. First and foremost, the Internal Revenue Bulletin, a weekly publication from the IRS, is the authoritative instrument that announces official rulings and procedures of the Internal Revenue Service, as well as Treasury decisions, executive orders, court decisions, and other items of general interest. The Internal Revenue Bulletin is used by tax researchers and practitioners to monitor regulations and other Treasury pronouncements. And you'll notice that the majority of the documents identified as substantial authority in income tax law that we've just been reviewing are reproduced in the bulletin. I thought I'd also wrap up by mentioning a few prominent commercial publications and databases in tax. First, Tax Notes is one of the go-to commercial publication series for tax practitioners. It offers three main titles: Tax Notes Federal, State Tax Notes, and Tax Notes International. These publications reproduce major primary tax sources as they come out, such as the text of new tax regulations, and they also contain articles providing news and analysis of the latest tax law and controversy. And finally, I'd be remiss if I didn't mention the plethora of tax-specific subscription databases available today. These research platforms are designed specifically for tax practitioners and include a combination of primary and secondary authority, as well as practice-focused tools like litigation checklists, tax calculators, and more. What really sets these databases apart from each other is the secondary source materials that they offer, many of which are prominent commercial publications in tax law. Bloomberg Law Tax, for example, is a standalone research platform from Bloomberg Law, and it's the exclusive online home for the BNA tax management portfolios, a popular research publication of tax practitioners. Thomson Reuters Checkpoint contains several tax publications from another administrative law publisher, the Research Institute of America, or RIA, including the popular Warren, Gorham, and Lamont tax treatises. And probably least familiar, but only because they've just changed their name, is Vital Law, which was previously known as Cheetah, and before that, IntelliConnect. Vital Law is a database from Wolters Kluwer covering a number of administrative law subjects, including tax. And the tax title they're probably best known for is the Commerce Clearinghouse's Standard Federal Tax Reporter.
It's hard to overstate the value of the Tax Notes series in doing tax research and keeping up with tax law. Unfortunately, it's not available on Lexis or Westlaw. You find it on taxnotes.com, which is a subscription database.
To wrap things up, when conducting tax law research, resources abound with varying levels of authority. The biggest challenges are knowing what to look for and how to keep up with the rapid changes in tax law. Fortunately, resources like the Internal Revenue Bulletin and specialized tax databases and commercial publications offer a helpful means to keep up to date on the latest tax developments. And my biggest piece of advice is, when in doubt, ask. Ask your supervising attorney, or even simply reach out to a law librarian for assistance. We're always happy to help.
This has been Sources of Tax Authority.
Thank you for joining us as you break into tax.
Don't forget to like this video, share it with your friends, subscribe to the Break Into Tax YouTube channel, and turn on notifications so you don't miss a single video.